A lot of people assume mediation in an Arizona divorce case is optional. Most of the time, it isn't. In fact, most judges in at least Maricopa County will consider mediation a prerequisite to being able to set your case for trial, meaning the judge wants you to have exhausted every effort you can to try to resolve your case with the opposing party before presenting the case to the judge and the judge making the ultimate decision. This is designed to, one, help people dictate the terms of their settlement agreement, and two, and more importantly, it's designed to keep people from litigating cases, incurring costs associated with litigating cases, and then having a judge make a decision over your property and your children that you might not have wanted them to make. If mediation fails, we're typically going to start gearing your case up for trial. So if we exhaust the option and we try to resolve it between the parties, but for whatever reason we have a situation where we're just at a stalemate and it's not going to be resolved, we'll typically start to get your case ready for trial. It's going to entail making sure we have the documents and witnesses and everything lined up appropriately, perhaps experts lined up to make sure we're ready to litigate, and then we're going to make sure you're ready to litigate. If you can't settle at mediation, you're usually going to be looking forward to a final adjudication hearing, some type of trial, and that's how we're going to get your final issues resolved and decided by the court. Divorce trials in Arizona can be tricky. One of the most important things for people to remember is whether you're represented or not, you are held to the same standard as a practicing attorney. Divorce trials have several stages. Typically, you're going to have one party, usually the petitioner, is going to go first in that divorce trial. They're going to present the entirety of their case. They're going to outline their exhibits, their witnesses, all of the different information that they want the judge to hear in order to rule on what their positions are. And of course, you're going to be very clear, ideally, about what exactly it is you're asking for. Then the respondent is going to have their opportunity in trial, their opportunity to present evidence, witnesses, testimony, and make sure that they can have their positions heard. After both sides have an opportunity to present testimony, the judge will sometimes give closing arguments, time for closing arguments, where you can wrap up your case and make very clear to the judge what your positions are, why you believe the court should find in accordance with your positions rather than the opposing party's positions. And then usually the judge will take that matter under advisement and issue a written ruling within about 60 days. That written ruling is going to be binding. It is a final order of the court. It is very important that you try to resolve your case prior using other avenues, because you do not want to go in front of that court for 2 or 3 hours, try to explain the entirety of your life, and then have a judge just issue a written ruling that you're not comfortable or happy with, because the likelihood is you're going to be stuck with that ruling. Most, if not all, divorce issues can be resolved without a judge making an ultimate decision. And what that's going to look like is you and the opposing party working together to try to come to agreements. If you guys can't come to agreements, the judge is the final say. The judge is the final trier of fact who's going to analyze the evidence and decide what's going to happen. But most, if not all, cases are capable of being handled and decided prior to ever seeing a judge. The reality is usually it's either one party or both parties that are being stubborn or unreasonable, or there's some sort of issue that we are just absolutely stuck on, and that's what we require court intervention for and an actual judge decision to make. Several portions of an Arizona divorce decree are modifiable after the actual divorce. The big portion of the divorce decree that cannot be modified is the property and debt distribution. Once your property and debt are decided by a judge, they're set in stone. Absent appellate options, which are typically going to be relating to legal issues, not you not agreeing with the court's decision, you don't have the ability to go back in and modify, for instance, someone being awarded a house. There are other sections of a divorce decree, such as support sections or child-related sections, parenting time, decision-making, that can be modified after that divorce decree is entered. But when you're thinking about property and debt distribution, the best way to think about it is it's absolutely final.